My PPT is visible.
Yes,
Good
yes, sir.
morning,
Yes, sir.
everyone.
Yeah.
Today, uh, today's technical session's topic is IPR enforcement and litigation, practical insights. So today we have with us Professor N. Venkateshwarlu, Professor and Head, Department of Law, Osmania University. So I would like to welcome you, sir, and
Thank
I would
you.
like to invite my friend, my colleague, Krishna, to give a concise introduction of today's speaker.
Good morning, everyone. Namaste, sir. On behalf of
Namaste.
Department of Law, I welcome you to this session. So it is indeed my pleasure to introduce resource person of this session, Professor Dr. N. Venkateshwarlu, sir. He is a distinguished legal scholar and academician currently serving as a professor of law and former joint secretary at the UGC Legal Bureau, New Delhi. With expertise in corporate and securities laws, alternative and online dispute resolution, IT law, intellectual IPR, and human rights, he has made significant contributions to legal academia and research. Over his illustrious career, Dr. Venkateshwarlu sir has held various leadership positions at Osmania University, including head of the Department of Law, principal of PG College of Law, and additional controller of examinations. He has guided numerous PhD and LLM students, authored several books, and published extensively in reputed national and international journals. Recognized with prestigious awards such as the UGC Research Award and Telangana Sri Sava Award, he is frequently invited to deliver lectures at esteemed institutions and international conferences. His dedication to legal education, policy research, and academic excellence continues to shape the legal academia in India as well as beyond in India. Sir, with this brief introduction, I once again welcome you to this session, sir.
Thank you, Krishna. Jayant, can I proceed?
Yes, sir. Yes, sir. You can proceed, sir.
All the participants are joined.
Sir,
No,
not
sir,
yet,
they
sir.
will be joining. Yes, sir, they are joining soon, sir. You can start.
Okay, right. Very, very good morning to one and all. Respected Dean Faculty of Law, Professor Baswarajji, Head of the Department, and Program Coordinator Jayanta, Young Professor of Department of Law, Central University, Karnataka. First of all, I want to congratulate, appreciate Department of Law, Central University, Karnataka for choosing wonderful topic area for faculty development program, and also welcoming all the participants who are from different places from India, and administration, registrar, vice chancellor of the university. Thank you for giving me opportunity. First of all, I want to request all the participants, please open your cameras. Since it is online program, you must have online ethics. Because in my class, whenever I am in the class, I used to call my students by name to know the understanding level and importance of the topic and how he is understanding the topic by seeing their faces, by seeing their attendance in the class. I can assume. Like that is the reason I am requesting all the participants, please open your cameras. Then recently, many things are happening through online. Some of the participants are not concentrating properly. Some of the participants are in mute. Many things are happening. To avoid all these kind of things, I am requesting participants to open your cameras. And
Kindly open your cameras and show your presence in this wonderful and productive session.
what's that?
Sir, I'm requesting all the participants to open your camera once and show your constructive presence in this session.
Thank you. Actually, intellectual property rights, it is different kind of specialized topic. In this area, you can find scientists, non-scientists, lawyers, social scientists, different kind of people may take part in this area. As a law scholar, as a law faculty members, our role may be a little different. This is just like a different kind of society. Inventor maybe invent something for their property protection. We require specialized law. You may call them as lawyers, advocates, attorneys, IPR attorneys, many names you can give. But our duty is to protect the property. That is the reason my PPT is visible.
Yes, sir.
It
Yes,
is
sir.
visible.
Yes, sir. Yes, sir.
Yeah. Second slide is visible. Quotation
Yes.
of the day.
Yes, sir.
Yeah. My quotation of the day is, the power of the lawyer is the uncertainty of the law. Jeremy Bentham. From this quotation, I am starting. Introduction to intellectual property rights. You can divide intellectual property right like this: intellectual plus property plus rights. You can say IPRs. We studied since LLB transfer of property rights, property, different kind of properties and etc. But in olden days, we don't have intellectual property rights subject also. Later on, in law, intellectual property rights subject also introduced for many reasons. Now it is very useful to the law fraternity. Origin of international IP regime started at Paris Convention on Industrial Property 1883. Copyrights at Berne Convention 1886. The above two international efforts can be termed as Magna Carta of IPRs. What I am trying to say, these concepts are not new to the system. These concepts are old one. Because of many reasons in India, we could not witness many developments in the field of intellectual property rights. But after independence, in our India, many things have happened. In 1951, we got industrial economic policy, but it could not achieve their goals. Many reasons are there. We got independence in the year 1947. Companies Act came in the year 1956, and other economic laws are not yet commenced because of our political conditions and our situations, local politics, and our Indian scenario. That is the reason we can say that we are confined to only localized kind of things, whether it is education, whether it is economy, whether it is scientific, and you take any kind of thing, we confine to only India. When you go to international framework of intellectual property rights, WIPO came into force 14th July 1967. but India was not the member, because just now I said we had many problems in the field of in science and technology, education, economic, and other kind of things, whatever. That is the reason 75 we became member in the WIPO, World Intellectual Property Organization. And before 1975, we got FERA. Before FERA, we got FECA, Foreign Exchange Control Act 1947. 1973, Foreign Exchange Regulation Act. 1999, FEMA, Foreign Exchange Management Act. These three legislations are very important to know the differences, to know the developments which are happening in and around the Indian economic system and our policies also. You can say that in the 1947, we confined to only control. 1973, just we changed our policies and our foreign exim and export kind of policies to FERA, Foreign Exchange Regulation Act. Then 99 FEMA. Keeping these three developments in your mind, also to note that new industrial economic policy came in the year 1901. Anyway, that was replaced by industrial economic policy old one. 1/1/1995, WTO came in the place of GATT. Global concept came from TRIPS and WTO agreement from 1/1/95. From 1/1/96, World Intellectual Property Organization plus WTO cooperation started. Things are happening very fastly. India became member. Many kind of things are developing in the field of intellectual property rights. And I can say that University Grants Commission also say intellectual property not only confined to law, not only confined to science, not only confined to engineering. It is interdisciplinary kind of subject. Means today intellectual property can read by agriculture graduates, engineering graduates, commerce, business management, law, science, and even some of the universities are social sciences also. This much of interest, this much of importance has come for intellectual property rights. That is the reason when we have these kind of when you have these kind of people, these kind of persons who want to know the developments of intellectual property every day. But finally, I can say that everybody is thinking about protection of intellectual property rights, enforcement of intellectual property rights, and how litigation is there. Suppose one scientist is there. If he want to invent some kind of formula, he must confine to his laboratory for several years, sacrifice his family life, friends, society. Many kind of sacrifice he has to take place. But after inventing something, if we don't have protection, then automatically it is waste. That is the reason nowadays lawyers' role has become more important in the field of intellectual property rights to protect the rights of the inventors. That is the reason lawyers' role has become more important in the field of intellectual property rights. Most of the lawyers, especially in the metropolitan areas like Hyderabad, Bombay, Calcutta, and in Delhi also, most of the advocates are turning to become IPR attorneys. Many things are happen. One trademark, I listen 10 lakhs fees. One trademark issue. Some of many kinds of things are happening in the field of intellectual property rights. You know, categories of intellectual property rights. Industrial property, that you can divide it into two categories. One is industrial property and copyright, patents, trademarks, industrial designs, geographical indications, biotechnology, traditional knowledge, indigenous knowledge, and many. You can say another 5 6 kind of industrial property under category of intellectual property. Many plant varieties are also came. Many things are coming. So much of research is taking place in the field of science and technology for innovations and everything. For that, our role is becoming day by day very important. Coming to the other kind of property, that is copyright, literary, dramatic, artistic, musical, cinematographic, photographic, and other sound recordings, and even nowadays all electronic kind of CDs and other kind of things also, and many kind of online issues also coming under copyright. Kinds of property, movable property, car, pen, book, furniture, dress, you can say under movable property. Immovable property, land, building, intellectual property rights, copyrights, literary works, industrial innovations, patents, designs, etc. You can say many kind of things. Here I want to enlighten some important thing is that suppose if any person having 2 acres of land somewhere in your place, in your working place, otherwise, first of all, every human being thinks that how can we protect our property? What we will do? By fencing, by appointing watchmen, by one notice board, and other kind of security measures you have to take for your protection of the property. Every Sunday, whenever you get holiday, you used to go and verify whether my property is there or not. Why? Why? Because here that property worth maybe in crores, some lakhs. Your hard and money you kept for that property, you earned that property, you have to take care of that property. Same in the case of intellectual property rights. Suppose if you fail to protect your intellectual property, that property may be stolen by some other people. Now we are calling them as infringement of the property in the intellectual property. Some other kind of malpractices also taking place. That is the reason, as an inventor, you must take proper steps in the present scenario. That is the reason, after inventing the property, you must take care of your intellectual property like your immovable property, lands and other buildings. For that, you must appoint lawyer, IPR attorney to take care of registration, to take care of transfer, to take care of mortgage, licensing, and other kind of things. That is the reason you cannot keep your property in your almara. You cannot keep your formula in your packet. Whenever you invented that property, your basic duty is to transfer that property to some other organizations to get fruits from your invention. Then only that is valuable. Otherwise, after inventing, keeping much of interest and days and money and everything, after many years, if you invent something and keep in your almara, that is not correct. You must transfer. But nowadays, transferring property, this is not that much of easy, because your advocate must have professional ethics, and while handovering that formula, that invention to the IPR attorney, he must take care of that property to register the property. Nowadays, many things are happening. Physically, you can register, you can submit application form to the concerned registration office people. Otherwise, you have online procedure also there. While doing online and other kind of things also, here advocate has to take care many kind of steps. Then otherwise that may be stolen by some other people. That is the reason here, not only the inventor duty, not advocate and IPR attorney duty is also very much important to register the property. Once you register the property, then how can you get more money? What you invested. Number one, suppose if you are working under government organizations, as a scientist, your duty is to do something, get patents, designs, trademarks for different purposes. That also, as an employee, your employer will take care of those patents and everything, and even the patents also comes under the name of your employer. That is very important. When it is converted into economic power, economic benefit, obviously many things are happening. Suppose while transferring your intellectual property rights, you must have Indian Contract Act 1872. You have to go for agreement. While writing agreement, you have to take many steps. Section 10 of Indian Contract Act essentials must be appear in the agreement. Not only 10 essentials of agreement, you have to take care of arbitration clause, and what are the clauses you must write in that clause. Nowadays we are treating not only 10 essentials, we are treating arbitration clause also becoming one of the important essential in the agreements. When you have strong agreement in the process of transferring these kind of thing, then only inventor will get benefit. Otherwise, today's my quotation is saying any lacunas are there in the agreement, any lacunas are there in the system, in the law, automatically other party will take advantage. That is the reason to avoid many kind of things. You have to take care. Second one is, all we are professors, we are working for the organizations. Recently, Government of India given opportunity to all the law universities in India, anonymously, they sanctioned IPR shades to do better research on intellectual property rights. This is only for law. Whenever you go to sciences, even they are also getting many projects on the name of IPRs. And why I am trying to say these kind of things means, Government of India is very keen on doing these kind of researches to encourage the inventors by different means. When you have this kind of policy, second important is that protection. Suppose if there is no proper protection to the inventor, I think inventor may not come to outside to do these kind of better things. Because our duty, Government of India duty is also to encourage the inventors. When you are, how can we encourage? By giving protection. Suppose today, scientist means engineering, you can say that illiterate of law. Suppose engineering graduate, I am treating he is a illiterate of law. When you have these kind of systems, your lawyer's duty is become very important. You have to protect them, convert that protection into economic. Then only that fellow go for more innovations, and you work for better things in the society. Indirectly, all these kind of things are putting India in number one, number two places. We are trying for that also. And even now, many things are happening after new industrial policy. Just now I referred many kind of things. After 96, our economic laws are changed. Our policies are changed. Our many laws are updated, amended for the to give competition to the entire world. That is the reason today our GDP also reached after IBC introduction and other kind of things. Now we are in better position when you compare with other countries in the world. Now, coming to the nature of intellectual property rights, creation of human mind, intangible property, we cannot see the property, exclusive rights given by statutes, legal rights. When you have legal rights, automatically courts has to intervene in the protection of for the protection of the inventor. Suppose if you don't have law, you cannot protect them. Now, when you have legal rights, when you have legislation, that is the reason you can protect the inventors by using statutes and their legal rights. Next, attend with the limitations and expectations. You know, copyright is there, life plus 60 years, patents are there, 20 years, and other many limitations are there. This is nothing but absolute right over the property. Just like just now I referred immovable property. Same in the case of intellectual property rights also. Inventor get owner get, otherwise I am using owner, inventor, property owner, you can say, to easily understanding. You have his own limitations and exceptions on this invention. Time bound also there, territorial jurisdiction is there. All these are concerned in nature of intellectual property rights. Coming to the very important national IPR policy 2016. 2 days back, I sent national IPR policy document to jail to circulate among all the participants. This is very important document on national IPR policy. After complete, I hope after completion of this FDP, I am requesting all the participants must apply IPR project. It may be MRP, it may be major research project, otherwise IPR chair for your organization. Government of India immediately sanctioning. Suppose I think I hope some of the participants may be national law universities. Just to verify whether your university got sanctioned IPR chair or not with your administration. Suppose if IPR chair is there, you can become IPR chair in charge also to do many programs. You can conduct seminars, workshops, training programs, and major research practice. So you can give to some others, and you can appoint research assistants, principal investigators by giving 40,000, 30,000. Many things are there for the intellectual property. DPIIT organization is, please note down, Department of Promotion of Industry and Internal Trade, DPIIT. Just you click in the Google, you will get many things about DPIPB. Now they are very much, because March 31st is I think is the last date. I listened somewhere, I don't know records. Before last year, many organizations are spent back unspent amount without spending. For that reason, DPIB, IIT also send legal notices and not legal. Directly, I cannot say legal notices. Show cause notices they served for organizations. Why you are not spent that much of amount also? That much of benefits are there. After this program, if you call me, I will give correction of. I will give what you call link also for applying that kind of thing. And based on that, IPR awareness is conducting, generation of IPRs are doing, legal and legislative framework is going on, administration and management things are happening under national IPR policy, enforcement and adjudication and human capital development. On this concept only, they are spending crores of rupees on these kind of projects. Just now I referred national law universities. without applying project, they sanctioned IPR chairs to national law universities. Please note down, because I was a member in selection of IPR chairs for two three universities. That is the reason I came to know that these kind of programs are sanctioned to the national law universities without applying also to encourage the law faculty members, law universities, like anything. That is the reason FDP, you are in the FDP, please, after completion of this program, please use yourself and open DPIP, IT website for betterment of your projects and your career, academic career also. Next one is national IPR policy. What for it is? Modernization of IPRs. Next, fee reduction, expedite examinations. Suppose patents are there. After 20 years, he must go for registration. Otherwise, it will go to public domain. Before that, if inventor did something more on particular existing patent, he can go for even renewal also. By observing many kind of things, they will give renewal. That is the reason expedite examinations, commercialization of support, review and support. Suppose after 1195, our whatever the intellectual property rights inventions are there, not confined to only India, but entire world we have to give competition. That is the reason our inventors has to work properly, and our lawyers and IPR attorneys also work properly to take care of international laws as well as other kind of things also. And next one is achievements under new IPR policy. This is very, very important, because young like you must know the things, what are the things are happening in the society. Just now I said, India, because of all these research developments and new IPR inventions and etc., India is trying to stand 2-3 rank in the world level. And also GDP also increased because of these encouragements and innovations and everything. Improvement of GII ranking, Indian rank in the Global Innovation Index, issued by WIPO, has improved from 81st in 2015 to 52nd in place 2019. India retains 40th rank out of 132 economies in the Global Innovation Index in the year 2023 rankings published by the World Intellectual Property Organization. Latest, India's ranking in the Global Innovation Index has been improving over the years, and in 2024, India ranked 39th out of 133 economies. The GII is published by the World Intellectual Property Organization. Now we are in 39th state in the year 2024. I hope every year it is coming down. That indicates after 5-6 years, I hope India may be 5th or 6th rank in the world ranking system. Our Jayant is really, I'm appreciating, because he is a young professor. He's chosen a wonderful topic. It is very much required to professors like you. That is the reason I hope by conducting more kind of programs like this, maybe everybody will encourage and go for applying projects and work for innovations, patents, designs, and everything. Finally, our India maybe come down to 5th, 6th rank in coming future. And and the registration of copyrights. You know, this is, since it is property, you have to register as per legislations, and some of the registrations, some of the patents are there that is not compulsory for registration, that is optional. You know, Even will teach in the classroom also. Suppose if partnership is also not compulsory registration. If there is no registration, many problems are happening nowadays. Courts are not entertaining non-registration of copyrights, non-registration of intellectual property rights, non-registration of partnership firms and other kind of things. That is the reason as a student of law, you must tell them to the general public or innovators, engineers, scientists, agriculture scientists, whoever it is. You must encourage them by conducting seminars, awareness camps in the different places, that whatever the property is there, whatever the cost it may be, you must go for registration, then only you will get legal rights. Then only courts are entertaining without seeing any kind of negatives. Suppose if there is no registration, many kind negatives are attracting for that kind of thing. To avoid all this kind of thing, you must tell them while conducting seminars like these kind of programs, registration is mandatory. Whatever it is, because property is some worth. That may be crores, lakhs, thousands, whatever it is. But registration is compulsory. That much of encouragement you must give by the by your organizations conducting many kind of programs. Administration of the Register of Copyright Office working under the CGPDFTM. It functions Controller General of Patents, Designs and Trademark. Many kind of organizations are there. Each kind of intellectual property taken care by each department, each ministry also. That is the reason. That is the reason you have to find out what kind of intellectual property it is and where we have to go for registration. Then only you have to work on registration of process. For that, recently in Hyderabad, one of my research scholar, I don't want to reveal his name. He has charged 3 lakhs rupees for registration of patents. And in another cases, trademarks, 2 lakhs. Just to imagine where you are. That is the reason so much of importance has come for registration of patents, registration of designs, trademarks, and etc. So much of litigation is there in the trademarks nowadays. Many kind of problems are coming in the case of trademarks, because minor changes in the trademark, minor problems in the trademark, in the designs. That is the reason people are coming for legal opinions and filing the cases. Many things are happening to avoid all these kind of malpractices in the society. Out of office situated in Delhi, Calcutta, Mumbai, Chennai, and Ahmedabad. Why I am referring all these things? Each patent have different offices, different places. Chennai, in southern region, geography, litigation, registration, Chennai, patents, Chennai, copyrights, Chennai, means South Indian people are identified one big city, that is Chennai is the coordinate for all the South Indian people. Mumbai, Calcutta, Mumbai eastern region, Calcutta east region, Delhi north region. That is the reason they divided all these kind of facilities to entire India, to help the innovators, to help the IPR attorneys, advocates to do better things. We have IPR training academy at Nagpur. People are attending monthly, every 2-3 months one program is going. You can go through, you can open your website, that website, you can apply for training program also. They will invite even professors, even students, research scholars. You can take that benefit also from the training institution. Traditional principles related to property rights. Suppose when you got property, immediately you will think that control over the use of the property, right to take any benefit from the property, right to transfer or sell the property. Please keep these kind of things are very important. Right to exclude others from the property, And finally, I can say that you will get monopoly rights over the property. You will get absolute right over the property. When you have these kind of situations, these kind of facilities, these kind of rights over the property, automatically you have to take care of that property. Otherwise, if you keep it open, obviously other people will take advantage by copying, by transferring, by stealing. Whether many things are there for malpractices, other people will make infringement of this kind of thing. That is the reason you must have legal knowledge. You must, otherwise you depend on lawyers, IPR attorneys, for betterment of these property rights protection. You know, just now I used monopoly rights over the property, absolute right over the property. Means when can you say, after getting certificate from the registration office only you can say that I am absolute owner. Without certificate, without registration of the property, you cannot say I am absolute owner. I have got monopoly rights. When you want to say, you must go for registration. You must depend on the very good IPR attorney to do better things. And you know, patent is 20 years, trademark is 10 years. You can go for renewal. Copyright lifetime of the author plus 60 years, geographical indication 10 years, and other kind of intellectual property also have their own limitations, time period for validity of those periods. Recently, okay, whenever I will discuss. Rights of owner of the copyright, economic rights of a copyright owner, right to reproduce the work, right to distribute in the market, right to communicate to the public, right of adoption, right to translate, right of paternity, claim the ownership, right of integrity, protect the reputation, right of retraction, of protecting the so far gained reputation. These all kind of rights will be available to the owner of the copyright, absolute owner of the copyright. When you got this certificate only, you can claim whatever the rights. Now I explained all these things on the PPT. And this is also very important. Indian Constitution and IPR. You know, I don't want to discuss more on Indian Constitution. If you go to Indian Constitution side, today may not sufficient to discuss more things. That is the reason I confine to only Constitution originally provided for the right to property. Provisions relating to right to property were changed the number of times. 42nd Amendment of 1978 deleted the right to property from the list of fundamental rights. New provision Article 300A was added to the Constitution, which provides that no person shall be deprived of his property save by authority of law. Even this kind of information is also applicable to the intellectual property rights. And also, directly we cannot say whether Transfer of Property Act 1882 is applicable to the transfer intellectual property rights. You cannot say directly yes, but we are using Transfer of Property Act 1882 to transfer all intellectual property rights to others. Just now I referred mortgage, sale, and assignment, and many kind of things are happening in the field of intellectual property rights. Many cases also are coming for court's opinion, lawyer's opinion. Even you cannot find more 4 or 5 IPR attorneys in the Hyderabad. Just to imagine, they were very busy. Means things because Hyderabad is meant for pharmaceutical hub of the India, Hyderabad. In Hyderabad, many litigations are coming from pharmaceutical area. That is the reason for people are working for like anything. Who is working on trademarks attorney is my PhD scholar, completed PhD on trademarks also. That is the reason many opportunities are there in the field of law. You can encourage even your students also to go for IPR attorney by writing exam. Otherwise, without exam also, you can go for IPR attorney. Next, socio-economic importance of IPRs. IPR promotes innovation, which leads to economic growth. Finally, we can say that whenever whoever comes to you, ask IPR is what kind of subject? IPR is economic law. IPR is corporate law. But IPR may interdisciplinary approach kind of subject. Means finally protection of property, IPR property, you must go for lawyer or IPR attorney who are having LLB degree. That is very, very important. And provides income and causes movement of all kinds of resources, and therefore creates industry and commerce. The intellectual property has a very important role both in economic and social development of mankind. Intellectual property right has economic value like any other property. Just now I referred. Many examples also I given. You have to see intellectual property towards economic development only. Economic criteria only, like other properties only. Indian Contract Act IPR. Anyway, I referred while preparing after registration of IPR. Very next step is to transfer your IPR property to some other company or oblique any individual, whoever it is, corporate or any individual. While transferring, very first question is agreement. Preparation of agreement is very, very important. Recently, contract administrator, one post has evolved for lawyers. Please note down, contract administrators. Their duty is to prepare only agreements. That agreement should not attract any kind of legal problem in the future. That kind of agreements has to prepare by only experts, lawyers who are working for agreements only. Just now I referred of not only 10 essentials of valid contract. One more essential also came. That is arbitration. Suppose without arbitration clause, many problems are coming. Suppose it is civil litigant. In Hyderabad, recent survey after discussing High Court judges and judges who are in the district courts, because many are my students, many are my friends. When I discussed with them, sir, once upon a time, civil court has had many cases and busy. In call work goes up to 2 o'clock. Only trial will start from after lunch. Now, before 11 o'clock, we are completing call work. 11 o'clock onwards, we are becoming free. After 2 o'clock, we are taking relax in the chambers. This kind of state, please note down and quote my name also. Why arbitration has become more popular nowadays? Because when you are writing arbitration agreements, when you are writing clauses in the arbitration, after preparation of this, no one is coming to civil courts. No one is going for lawyers who are practicing for civil cases. Simply they are depending on arbitration. They are going and settling the matters in 1-2 sittings. Betterments are so many things are there. Whenever that issue comes, I will discuss. Coming to the litigation. No, nowadays, many arbitration, lawyer office, pre-litigation, outside the court settlement, section 89 CPC, and you have many rights. Court, you can go to court, you can go to some other kind of things. That is a mediation. Many kind of things are there for this kind of litigations. But here, most of the lawyers who are at district level, they are not aware about these kind of systems. That is the reason after seeing my topic, which is allotted to me by Jain, I appreciate it, because IPR litigation and enforcement Very good topic, because everybody knows. Recently I seen IPR syllabus of LLB, not LLM, LLB, because I am teaching LLM students, that is corporate contracts. In that corporate contracts, we have IPR contracts also. That is different area. But this is the important thing, because after completion of LLB, everybody must go to practice. Well, for nowadays, many 100 kinds of practice procedures are there. You can choose any kind of litigation. You can choose many things. But what is the future? Suppose if you take IPR attorney as your profession, but how you stand, where you stand, how can you stand, what is the expertise you must have, where you get this expertise? These kind of challenges are coming to the new advocates, new lawyers who are going to the society. Even whenever I inquired with my students and scholars, they are saying that how can we proceed, sir? They are questioning me, sir. Suppose if I go to this litigation, IPR litigation, suppose if I start arbitration, who will come to me? Because any IPR related arbitration, they are depending on retired high court judges, retired district judges. Many problems are coming in practical way, and that is the reason I can give some solutions also. How can we proceed further by adopting this kind of procedures, this kind of practice, this kind of litigation? This is very important in terms of fees, in terms of validity of the clients, because most of these people are corporate clients. The corporate clients, you don't have any kind of more problems. Simply if you say this guy find out amount, simply they are transferring, they are handovering that file, but they are expecting more services from the IPR attorneys. Suppose if you say 10 o'clock somewhere the office, you must stand by 10 o'clock. Otherwise, he feels that he is not correct lawyer. He is not giving proper service. That is the reason next case may not give to the existing lawyer, not serving properly. That is the reason many issues are coming to the lawyers also while doing litigations. Coming to intellectual property rights, litigation and enforcement in India. Now, you know, whenever litigation starts, penalties for IPR infringement in India are often seen as insufficient, with fines ranging from 50,000 to 2 lakhs. Just now I referred, one advocate is charging 3 lakhs for trademark registration, 2 lakhs for copyright registration. Well, while private discussion, they are saying that, sir, one company registration, long ago, we charged 1 lakh, 2 lakhs. Now things are totally changed. Charging 3 lakhs for registration of trademarks is not that much of amount to multinational companies. Simply they are paying without any discussion. They are paying lakhs of rupees as fees to the IPR attorneys. Just to imagine where you are, how you are going. Most of the lawyers, once upon a time, 10 years back, if you inquired 10 years back, advocates, no practice, nothing is going in the practice, there is no any kind of cases. Simply we are going and coming back to home. No, this kind of words I seen. But now we have to think about what kind of practice we have to choose. Just now I said 100 kinds of practices are there. In 100 kind of practices, suppose after choosing that practice, one kind of practice, you have to improve your talent and expertise in that field also. Imprisonment 6 months to 3 years, and seizures also there. This is not insufficient, because one property is crores of rupees of value. They are paying income tax, and many kind of things are happening like other properties. And imprisonment 6 months to 3 years is not correct. It must be improved for all the intellectual property rights also. Lack of awareness and understanding of IPRs. A survey conducted by the World Intellectual Property Organization, WIPO, found that only 30% of the Indian population has a basic understanding of IPR. Now you can link this information to 10-15 minutes back. I said Indian government IPR is funding crores of rupees to the scientific organizations like IICT, NGRI, many scientific organizations in the India. That is one kind of thing. Coming to the universities, yeah, all the universities, I think they have IPR centers. In the they are appointing one professor as IPR, he is looking after IPR center. From that center, they are encouraging students, staff, professors, whatever the inventions are there, on free of cost, they are getting patents from IPR centers of any universities. Suppose if you don't have IPR centers in your college or university, immediately with the permission of the registrar or vice chancellor, you must establish IPR center. Why I am referring this means you can apply project through IPR center, that become very easy to get crores of rupees as fund. Especially I am saying about traditional universities like Usmania, Gulbarga, and Allahabad, and all state universities. I am saying immediately after completion of your this FDP, you must go to your registrar and vice chancellor, enlighten them. You must have IPR center. If you have IPR center, through IPR center, you can enlighten, you can encourage your students, science students, commerce students, engineering students, agriculture students, medicine, I have forgotten to say, MBBS, all kind of streams. They must know the basics of intellectual property rights. After saying this, you can say that 31% of the Indian population means, just to imagine where you are. How can you expect 5th rank, 6th rank in the global ranking? By giving many funds. And also I referred, many organizations are refund. They received show cause notices because they are not spending money for seminars. They are not encouraging younger generation. They are not encouraging other section of people, society. They don't have basic knowledge on intellectual property rights. But who has to conduct? Professors like you must come forward and conduct many kind of programs. Then only make awareness. Otherwise, you cannot. How can you get awareness? Suppose all we are law college professors to conduct legal awareness camps for slum areas. We are going with the Legal Service Authority, along with the Legal Service Authority. We are conducting many kind of programs for legal awareness. Same legal awareness program. You can say that intellectual property rights also there. People have to work for intellectual property rights. This is also one of the important organization. Some organizations are there. This is also an important stream in the society. If you don't have innovations, if you don't have encouragement, we cannot go to the competition with other countries, and we cannot achieve better ranking. We cannot achieve GDP and other kind of things also. That is the reason we are encouraging FDP. 100% FDP is there for pharmaceutical industries. FDP is there 100% in some other areas. Why? We have to give much competition with the other multinational companies. Then only we will survive in the society. Otherwise, you cannot survive. Because of competition law, if you want to survive in the society, you must maintain quality, you must maintain other kind of better practices. Then only we will survive in India, in the practices, in the market. Otherwise, you will kick from the society, will kick from the market. That competition law says. Based on competition law, you can get protections also. Many protections are there to give competition also. That is also very important. Airtel case is there. Some other important Many cases are there. All the law faculty must go through the competition law cases also to know importance and distinctions between the IPRs and importance of IPR, why it has become more popular, how it is related to competition law. Many kind of things are happening. That is the reason previously we had Monopolies Restrictive Trade Practices Act 1969, but that was replaced Competition Act 2001. Why? Competition Act, MRTP was outdated. If you follow MRTP even now also, you will become outdated. We cannot give competition to other countries. That is the reason India brought competition law. It is working wonderful manner. Many cases are coming, and big players are also facing many legal battles in the competition commission also by paying more fines and other kind of things. Recently, SEBI also imposed many kind of fines based on the directions of the Competition Commission of India. Coming to the litigation and enforcement in copyrights, infringement that must be proven. That is, suppose in the case of physical property, suppose we have one plat somewhere, PLOT plat somewhere. Next, immediate person, if he encroached your property, immediately you must go to revenue people. Revenue people will come and conduct survey. Based on survey, they will decide boundaries and every kind of thing. Then suppose that fellow will say he is encroached your property. Like that, in the case of intellectual property rights also, same kind of, you must prove whether that other person is infringed your copy or not. Recently, in the case of copyrights, many things are happening in the Hyderabad. Suppose if you are an original author, they are taking information from the other authors' books and articles and other kind of thing. Some of the cases are came in the civil court. Immediately they are giving orders to stop sale that copies, and immediately injunction order also giving by the courts to stop produce that copies further. Many kind of orders also they are getting, and prove evidence such as a certificate of registration. This will establish your legal ownership of the work in question. Just now I said, though it is registration is optional, you must aware, you must enlighten persons who are doing these kind of things. First, they tell them to go for registration by adopting, taking advice from the attorneys and etc. Then only they will survive, and they will intellectual property will save. Otherwise, they cannot survive in the market. How can disputes be resolved legally without going court? This is very, very important. I think 2 times, 3 times already I referred. Number very important is that nowadays, since it is civil nature of kind of thing also, and also we got agreement, and also section 10 of essentials of valid contract, and also arbitration clause. Since it is civil dispute, first of all, whether it is commercial nature or not. Yes, 100% it is commercial nature. How can you say it is economic value? It is, even court fees also depends upon the value of the property. Arbitration in commercial matters also taking place. Commercial Courts Act 2015 came, 2018 amendment also taking place, 23 we got mediation laws. Many things are happening in the field of outside court settlement. Coming to the arbitration in commercial matters. Nowadays, what is going in the courts? Suppose if copyright owner filed a suit in the court of law, please note down now onwards, a very important thing, because most of the people, they are not aware about the litigation and enforcement procedures, especially in the field of IPRs. It is just like commercial matter. It is just like economic value. That is the reason These two things are comes under civil nature kind of thing. But suppose if IPR owner, if he filed case in the court of law by way of suit, same what kind of requirements for other kind of suits, other property suits, same kind of rules also applicable to the intellectual property rights. Suits, IPR suits. I can say simply IPR suits. Okay. Suppose after filing the suits, very next step is notice to the other party. While giving notice, if matter is serious, you can ask interim reliefs. You can ask stop producing. You can ask stop selling. You can ask any kind of interim relief for time being. Please note down. If there is no serious, you can serve the notice to other party. Other party may come as per the CPC with counter. I can say nowadays, please note down. Please start noting, please. Before filing the case in the court of law, judges and courts are insisting the parties to send a legal notice to other party before coming to the court. Without knowing that fact, some of the organizations are coming to file IPR suit without knowing that fact in the court of law. At that time, they are not numbering for that suit. Simply they are rejecting by saying you must serve legal notice before filing the suit in the court of law. This step has become very popular after introduction of civil courts law. 2015. After that, now people are sending legal notice. You may give 21 days, you may give 30 days notice. Other party will reply by saying, by admitting, by saying no, by saying yes, this is that, this is that. That answer will come from the other party. Then courts are entertaining suit for further. They are numbering suit. Now, in this case, sending notice, responding the parties from other side becomes very easy. They are coming with counter. Immediately, they are framing the charges. They are identifying the witnesses. They are getting the materials. Everything happening. They are deciding trial date also. Immediately, trial starts. Before commencement of charges in open court, they are asking the parties, court is asking, judge is asking the parties whether you want to settle the matter outside court settlement or not. Number two, please note down, number two, they are asking whether you are ready for court annexed mediation or not. Number three, whether you proceed further in the same court. These three questions they are raising, court is raising in the open court. Based on those statements, most of the people are going for outside court settlements. When you go for court settlement, again you have to go to some expert fellow. Based on expert fellow opinion, you can frame MOU, Memorandum of Understanding, and settlement deed. That settlement, after settling the issue, again you can request Secretary Legal Service Authority to send back to regular court for getting decree. After that, settlement deed will become part of judgment, part of decree. That is happening. Number second, mediation. That is happening in the court annexed mediation. Even that also they are sending to the legal service authority. There we have panel of mediators. Plenty of mediators are available to take care of particular field. Suppose some of the panel of mediator will expert in the bank cases, some of the panel expert in the insurance, some of the panel expert maybe in the IPR, some of the experts are in different fields. There are a lot such kind of people to settle the such court annexed mediations. Even they are settling the matters and going back to the court getting decrees. And another kind of thing is their pre-litigation. Before filing case in the court of law, when you got arbitration clause in the agreement, based on that, you can go for pre-litigation also. Next kind of remedy is that you can opt arbitrator also to settle the matter. Now we have many kind of things are there in the field of IPRs also. That is very important. Second one is, furthermore, you have venues like mediation center, Lok Adalat, which tries to settling disputes before the matter reaches court. Pre-litigation dispute resolution. Nowadays, pre-litigation dispute resolution has become more important in the field of law, because before filing the case only you must serve the notice, you must meet the other party, and you get result from the from him. Then only you go for further. Otherwise, no. For example, UGC has directed all the universities must have grievance cells of employees and students also. After the establishment of grievance cells in the different universities, even now some of the universities are not established. Purpose of introduction of grievance cells are that, suppose junior got promotion, senior deprived. Naturally, junior may go to High Court by filing WP. WP, after hearing 1 hour, simply judge says, admit your matter. After admit, they will send notice. That fellow comes after 5 months, filing counter. Here, issue is not between the parties, issue is also employer. Even employer also party, other beneficiary also party, and head of the department party, dean of the faculty proper party. Many people are suffers like anything to attend the court, filing the counter behalf of everybody. Many things are happening. To avoid all these kind of litigations problems, now even High Courts also suggesting petitioner to go and meet your employer. Where I have to go? Whom I meet? Where should I go? I don't know, because I don't have awareness. Till now, I know only one thing: if deprived, if my fundamental rights are violated, simply I can go and file WP in the High Court. That I know. But courts are now not encouraging, because so much of litigation is there. Prevalence litigations are more. Out of recently, Supreme Court judge said 5 crores cases are pending in different courts in India. I said somewhere in the meeting, 2 crores 50 lakhs cases are prevalence, duplication, without any justification. Simply they filed in the court of law. Now courts are saying that 5 crores. No, you can deduct 50% of the cases are waste, hopeless. That is the reason, as a lawyer, as a professor of law, you must aware even your students and I think you must have legal aid centers because of Bar Council of India also instructed all the law colleges they must establish free legal aid and family counseling centers, legal aid centers. They must conduct. They must work with the cooperation of the legal service authority of the nearest court. All these things are happening for the betterment of all these kind of problems. Now I referred that fellow who comes for grievance cell. You must aware them. Every organization must have grievance cell. That grievance cell is taking care of is representation. After receiving representation, person who are heading that grievance cell, in most of the cases, senior professors will be the chairman of the grievance cells, retired professors also. That is a composition. In such cases, they are calling the records and seeing the records and giving reply to the is representation. In many cases, I will give only one example. In recent one of the issue, that fellow not passed departmental tests. Junior passed, junior got promotion. He is not seeing this fact anywhere in his representation. Simply is going to High Court, disturbing many relatives, disturbing law professors here and there, and many elders in the society, but not by saying I am not qualified departmental test. That is the reason these grievance cells are very much utilized, very much giving these kind of replies to the persons who are suffering like anything, by without any reason. After receiving this kind of answer, if we go to any advocate, basic advocate, he can say that there is no case. That is the reason in the Telangana High Court, I can say minimum 20-30% of the writ petitions have come down. Means courts are not entertaining frivolous WPs without any notice or reply from the employer or any other organizations. Now, after adopting this kind of procedure, now courts are moving very faster. Really, deprived people are getting reliefs within the time. Previously, what happened? Unnecessarily, call work will go up to 2 o'clock. After lunch, only 2-3 orders. Simply, passovers will take place. Even passovers also after 1 month. Before that, he will die. That things also happen. That is the reason to avoid all these kind of practices. Now, grievance is also encouraging like anything. This kind of information, whatever I said now, you can extend to the IPR disputes also. You can tell them, we have these kind of mechanisms in the present scenario. You must use, just I referred to university only. No, not only university. Any organization, they must have litigation settlement procedures. They must appoint, they must adopt, they must establish one kind of center to solve these kind of problems. And just now I referred to it to be noted that under section 89 CPC, all about disputes resolution mechanism can be used even when in court, and court itself can refer to settlement. This is also happening. You can use section 89 of CPC. I don't want to go into more details of historical background of introduction of section 89 CPC. I think most of the teachers may teach CPC and section 89 also. 89 is very important in the present scenario to settle the matters outside court settlement. Copyright infringement. Naturally, what happens? Reproduction, distribution, and communication to the public without the consent of the author. This is happening. Author, owner. That is happening. That is the reason suppose we in our program also, many professors are there. I think they may authored many books, articles, and many kind of things. Suppose if anybody used your work without your permission, naturally you will feel very bad, and also you can go for a legal battle also, because after spending 1 month time, article may be possible, 1 2 months only article may be possible by collecting data and writing many things and observing many latest case laws. Many things happens. At least 1 2 months will take. After spending this kind of time, after writing one article, if somebody stole it without referring your name is very bad. That is the reason. As a professor of law, I can say that this is nothing but crime, and you have to proceed further. Suppose if you maintain silent, tomorrow other person maybe take advantage. That is the reason. Without quoting your name, your work anywhere, you must take proper criminal action as well as civil also to prevent this kind of practices in the system. Then only you will get academic integrity. Otherwise, many kind of people problems comes, and younger scholars and young teachers and students may feel very bad because putting so many efforts, taking advice from the senior professors, writing one article, one fine morning without my name, other fellow copied and saying that I am the original owner means it is crime. That is the reason even we have criminal action and civil action also there. That is the reason instead of going civil, because it will take more time, criminal is better. I will explain in future. Selling, renting, or importing, infringing of copies of a copyrighted work without the consent of the author, owner, it is crime. It is civil wrong. That is the reason the author must take appropriate steps to do better things about the work and everything. Writing is one criteria. You may feel that I am very great. You may feel that I know everything. You may feel that I authored this article, I am the owner. But you must take care of your article forever also. That is very important. Suppose if you sleep for many days without observing this kind of things, somebody will copy and say that I am the owner. That is the reason. If you find somewhere it is yours, it is looking yours, immediately you must send a legal notice. Recently in Hyderabad, legal notice has sent and replied, say sorry, and I will withdraw. This kind of words also he given in his reply notice. Suppose if you complain to the police station, even SI rank people are involving in this system and they are phoning and calling the wrongdoers and they are asking explanation. Impose fine also, that things are happening here and there. I am listening. I can say only one thing. This is not correct. This is not sufficient. What is going in the society based on copyright infringement and litigation and settlement and enforcement. This is not correct. We got a very non-serious kind of situation is going in the courts and police stations also. Not like that, because this is intellectual property. Our mind is created this work. That is the reason we have to give much importance to our work by giving stringent laws in the field of copyrights and intellectual property rights. Creating a derivative work, also known as piracy, based on a copyrighted work, including the content available on the internet by unlawfully downloading or streaming the copyrighted work without the legal consent of the author, owner. Many things are happening. All we are writing PhD theses and articles and many research work is going. After checking our plagiarism percentage, only we are publishing the articles. Even many journals, many publishers are observing plagiarism, whether your work is original or not, then only they are going for further. Otherwise, without checking plagiarism, if they go for publication of book, again legal disputes, legal coming, even publisher also party in the civil and criminal cases also, because publisher duty is also check the legalities and observations about importance of the this kind of cheating, creating many legal problems. That is the reason publisher as well as author also take care of everything, that is infringement and other kind of thing, and plagiarism checking, for plagiarism also many softwares are there. You have to use very good plagiarism software, which is using by the your organization to claim legality more. Suppose some more free softwares are available, that is not correct. My suggestion is that you must go for your organization, whatever they are using. That is better to verify your plagiarism, because nowadays this is also becoming problem. Some of the authors are claiming that, sir, I verified, sir. Where you verified? Sir, in the Google free software, sir. How much you got? 30%. Suppose if I send that same thing to some other software which is using by the organizations, they are saying 50%. This much of deviation is coming. That is the reason I am requesting all the participants now onwards which are taking publication, because publication is very important for your promotion, for your importance in the society, to become professor and to become very good academician. Articles are must, writings are very important. By observing this plagiarism only, you have to go further. Otherwise, you get many kind of problems in the future. You know, after all these things, I discussed arbitration, mediation, many kind of thing. Now coming to the suit, Supreme Court of India has held that suits against infringement of trademark and copyright can be instituted only in the district court that exercises jurisdiction over the place where the cause of action in whole or in part arises, in the case where the plaintiff instituting the suit against the defendants. I think you clearly understand about this statement. Supreme Court only clearly said whatever the IPR issues, especially copyrights, trademarks, and other kind of things, you got jurisdiction only district court. Before the district court only you have to file, and also they will decide which court is the proper court to trial your case and etc. They will decide after filing the case in the district court. Based on that, they will send notice. Just now I said all the stages of the civil suit. There is no any kind of different methods for IPR civil disputes. Once you say dispute, civil dispute, you must refer suit. That's all. Based on that, you have to work further. There is no any kind of other kind of methods. Suit means suit. Whatever the procedure is there in the CPC for filing the suit in the court of law, same procedure is only applicable for suit. Nowadays, other kind of things are there. Just now I said you can take that kind of advantage also. This is not required. A criminal enforcement of copyright. Just now I referred, according to the Supreme Court of India, an offence under Section 63 of the Copyright Act 1957 is considered cognizable and non-cognizable, meaning the police can register a case without a warrant and the accused cannot be granted bail as a matter of right. Section 51 of the Act, which refers to what amounts to copyright infringement. Offence under Section 63 of the Copyright Act 1957 is offence under Section 63 of the Copyright Act is a cognizable offense if punishable with imprisonment for 3 years and upward, but not more than 7 years, cognizable and non-cognizable offense. This is happening. Many things are happening. Suppose if you go to Delhi-based district courts, you will get more kind of this kind of district courts. Now, suppose in South India, I think Northeast, you cannot get these kind of cases. Delhi and some other metropolitan, especially I headed by UGC Bureau Legal Bureau. I had an opportunity to move with many advocates in the Delhi. Even I witnessed many kind of disputes like copyright suits and criminal cases and etc. We got not only civil, not only criminal, you got administrative remedies also under copyright. Administrative remedies consist of moving the register of copyrights. We have copyright registrar. First of all, before going to court and other places, my advice is that first you go and give representation to administrative. That is, who is the administrative head? Registrar of copyrights. He will ban the import infringing copies into India. When the infringement is by way of such importation and the delivery of the confiscated infringing copies to the owner of the copyright and seeking the delivery. This is happening registrar through registrar. Even registrar also doing better things for this. Okay. Next, coming to many things are there. Why it is? Oh yeah. Yeah. Criminal enforcement. Next, administrative. Ant and pillar orders. Especially, this is for only patents. An ant and pillar order is a court order that allows a complainant to search and seize evidence from a defendant premises without warning. It is often used in cases of intellectual property infringement, such as trademark, copyright, and patent violations. In these cases, what happening? Police people are going based on the ant and pillar orders which are given by the courts. Directly they are going and search and seize from the complaint from the wrongdoers' residence and offices, and they are getting back. They are handovering to the owner, or they will kept somewhere if case is pending before the courts and etc. This is comes under ant and pillar order also. You can go. Coming to counterfeiting. Counterfeiting is a type of intellectual property rights infringement. Many infringements are there. Kinds of infringement are there. Because I don't want to go into kinds of infringement because some other resource persons are maybe deliver lecture on types of infringement, other kind of thing. When that kind of thing will come, you ask them what is counterfeiting. Counterfeiting is a type of intellectual property rights violation, infringement that involves the illegal reproduction of a product or service. Counterfeits are often sold at a lower price than the original product and can be lower. Many things are happens in the society. Some iPhone earphones and some other accessories are available some here and there. They will say, sir, this is original. You can give only 500 rupees instead of 1000 rupees. This kind of things are happening even in the society also. People are purchasing that kind of thing. Immediately after using that goods, immediately spoiling without any receipt, we cannot do anything. That is the reason you don't encourage counterfeiting kind of things in the society. You must go to authenticated shop. You can purchase by taking receipt that is useful to the other kind of problems and etc. Suppose in the case of counterfeiting and infringement, if you go to any advocate for this kind of problem, very first question is where is the receipt? That is the reason people are suffering like anything. Don't go to this kind of sales here and there. Design protection. It refers to legal process of taking action against someone who is infringing on a registered design, which is a type of intellectual property, by filing lawsuit in court of law. This is very important. Most of the IPRs, when can you say suit, lawsuit, procedure is same. There is no any different kind of procedure. Whatever I said now, injunction, mediation, Commercial Courts Act, and whatever I refer, Section 89 outside pre-litigation and court annexed mediation, whatever I said, all these are applicable to all kinds of intellectual property rights. Please keep this information in your mind. Suppose now I am discussing designs. Once I said lawsuit in court to seek remedies like injunction, damages, to stop the infringement and protect the design owner's rights. All these are applicable to other IPRs also. Name only changes. Okay, whether it is patent, whether it is designs, whether it is trademark, whether it is GI and other kind of thing. Suppose I will give one important thing. Long back, Hyderabad biryani got geographical indication. That is for 10 years. Before completion of 10 years, Dubai hotel filed objection against Hyderabad biryani GI. Immediately after observing things, they cancelled Hyderabad biryani GI and transfer and new GI has given to Dubai fellow. Why these things will continuous process? Because knowingly, unknowingly, because this GI fact, the Hyderabad biryani, here also 400 years of history is there, Hyderabad. Before Hyderabad establishment and every kind of thing and introduction of biryani, before that only, Dubai people are started that kind of biryani preparation and everything. Some of the family members of Dubai came to Hyderabad. They started cooking Hyderabad biryani in the Hyderabad city. That is the reason GI goes to Dubai, not Hyderabad. This kind of many cases are there. If you go through very interesting factors, you will get by reading many cases. Registered design in India can be enforced by way of civil action. The remedies against infringement include interim and permanent injunctions as well as damages. You know difference between interim injunction, permanent injunction. If any kind of urgent is there, any much losses are taking place for particular issue, means immediately they will give interim action. Permanent action, injunction in the place of long benefits and long way till completion of the case. Sometimes longer dates they will give for permanent injunction as well as damages and everything also. In India, criminal remedies for design infringement are available under the Copyright Act 1957 only. There is no any major kind of things for designs. Whatever the criminal remedies are available to copyright, same criminal remedies are available to designs also. However, patent and design law do not have criminal remedies for violation of rights. This is very important. And patents, enforcement of patent rights can be done through courts and ADR mechanisms. What are the ADR mechanisms? Arbitration, mediation, conciliation, negotiation, Section 89, and other kind of procedures available under ADR mechanisms. Lokadala is also there. Because of that reason, in the case of enforcement of patent rights by taking ADR mechanisms, and also civil suit. So again, civil suit mechanism is same procedure. Names will change. In the place of copyright, patent will come. Once you using the suit name, sections and procedures as per CPC only, applicable. Suppose if you want to become IPR attorney tomorrow, just you go through procedure aspects of filing civil suit in the court of law, then you follow regular procedures that will become suit only. This is also one of the cases along with other civil suits which are filing for encroachment rights, which are filing for money suit, which are filing for other benefits, other kind of thing. Same kind of procedures also applicable to the IPR suits also. This is very, it is important to note that though the courts are very active in granting equitable rights like injunction, but are still very orthodox and careful while granting the pecuniary damages also. That is very important. Very first today I said after spending many days in the laboratories, by spending more money, sacrificing family life, sacrificing friends, society, one invention comes after 5 6 years. You just imagine for that many values are there. If you convert those values into economic, that is very important. uh, don't say that I sacrifice my family life. What is the equal treatment for my family sacrifice? That is not correct. You can convert lab experience, time and days and sacrifice, everything you convert into economy. That is a very important. You have to enlighten these kind of facts to clients. I'm using clients. That is very important because we are law professors, we are law teachers. You say them clients, you are liar. And I will give very good suggestions after completion of this class also. Even you can become, uh, after your office hours also, you can give legal advices on these particular IPRs also, pre-litigation cases also, family matters also. Nowadays, people are encouraging like anything. You must coordinate with your legal services authority. They will identify you as one of the member. Then you can do these kind of things after your office hours also. In Usmania University, for law professors also we are getting new benefit. That is whatever you give legal advices, services, legal opinions, and writing up agreements. You after taking fees, 30% of the amount you have to send to administration and main office. Remaining fees may be spent for your particular purpose, research purpose only. This is also happening, but people are not utilizing proper way. Civil remedies and patents enforcement. en- Enforcement is a crucial part of any civil litigation, and even in the matter of intellectual property rights. Parties can opt for various claims that can be made in an intellectual property suit during patent litigation, including permanent injunction, interim injunction, damages, accounts and hanging over the profits, anti-pillar orders, and other like seizing, also searching property, stopping publication, selling copies. Many kind of things are there. Not only, don't say that only stop. Publication also you can stop, and market also you can direct. Many benefits you can take from the courts by filing interim applications. Criminal remedies in India, apart from the civil remedies, criminal suit can also be instituted in case of infringement of trademark. Actually, infringement is more criminal than civil. That is the reason you can go to concerned police station and hand over application. Even they are also conducting investigation to protect the interest of the owner of the copyright. They are filing FIR. In that FIR, they are taking recording statement, and they are identifying the witnesses. And suppose this is very important, please note down. In most of the IPR cases, police people are refusing to take applications. Please note down. Please note down. Especially in the case of IPRs, police people are not accepting complaints from the owner of the intellectual property rights. At the time, immediately you go to regular court, magistrate court, file private complaint under 200 CRPC, get direction to the police people to do investigation on particular infringement of IPRs. Based on that, police people will go for raid, accused for seizure, infringing material. If it is serious, they will arrest for wrongdoers. Please note down, these are very important. It is also possible that a criminal suit can be initiated against known as well as unknown persons. It is also important to note that both the civil and criminal remedies, wherever applicable, can be availed simultaneously, and both the remedies can coexist, because most of the people, 90% of the people, SI and SPs, up to SPs, they are not aware whether what these property, these cases are comes under criminal or not. Because I think in the police manual as well as their training programs, nowhere mentioned about IPR protection and criminal cases and etc. Because while discussing with the police officers, they don't know ABCD basics of intellectual property, criminal cases. That is the reason once they are refusing to take criminal case, don't stop there itself. You must go to regular court, magistrate court, file private complaint. Please note down, private complaint under 200 CRPC. I don't know latest provision of BNSS. Please verify. To a regular court judge will direct the concerned police to investigate the case and go for seize and identify the accused people, arrest them, send to jail, and trial will take place, even like criminal cases also. This is very, very important to note down. Recommendations to improve the enforcement of intellectual property rights in India. Now I discuss many things. First of all, please note down awareness and education. The government should focus on increasing awareness and education about IPR among the general public, business and the legal community. Just now I referred, even law faculty along with the students, you must conduct legal awareness camps along with the legal service authority. While conducting legal awareness camps, IPR is also, you take one program for awareness. This is my suggestion. Please note down. Number 2 is streamlining the legal process. Legal process of IPR protection should be simplified and made more efficient to reduce the time and resources required for resolving IPR disputes. Just now I said, if you file suit, because since independence, okay, I can say since independence, before also we had CPC. Since independence, we are observing CPC. Some of the cases are taking 5 years, some of the cases are taking 10 years. While discharging myself as Director Legal Cell of Osmania University, when I was Director Legal Cell Osmania University, I was instrumental to dispose 60 years of case. They filed case in the year 1959. Recently, 2019, we disposed of that case with great difficulty. We could not identify witnesses. I request the judge to publish witnesses' names, notices in the newspaper, Your Honor. Then only they will come and give witness, otherwise they may not. Already 60 years over. Means 60 years suit as closed in the year 2019 of Osmania University property. This is a very good example what is going in the civil cases. That is the reason we got Section 89, Legal Service Authority Act, Arbitration Conciliation Act 1996, online dispute resolution, and information technology. We are utilized many kind of things for disposal of this kind of things. And you can go for mediation. Now you got also. You can go for pre-litigation. You can go for post-litigation. You can go for other kind of things are there. For that only, my suggestion is that awareness. Next, stronger penalties. Third one is stronger penalties. The penalties for IPR infringement should be strengthened to serve as a deterrent to potential infringers. This is not happening. In most of the cases, people are getting only 3 months, 6 months punishment. Simply they are getting bail after conviction in the lower court. Simply same day they are going and getting bail from the district court. This is happening. This is not suitable for wrongdoers. We require very stringent kind of thing. Then only IPR protection will take place. Coming to the specialized IPR units, in India, we are spending crores of rupees on IPR inventions. But innocent, intended IPR inventor is suffering like anything. Because government should establish specialized IPR units with trained personnel and allocate resources to handle IPR cases. Just now I referred, 90% of the people, they don't know full form of IPR. Please note down where you are. How can we save? How can you encourage people? How you reach the 6th rank, 5th rank? Next, coming to the technology-based solutions. The use of technology-based solutions such as online trademark and patenting filing systems. Just now I said, not only physical, you can apply through online also. Many changes are came. Even you are sitting in the chamber, you can apply and inquire about stages of filing. If any objections comes, you can comply those objections automatically. After fixed time, you will get certificate. That is happening. Next, coming to the online trademark and patent system can improve the process of IPR protection and enforcement. Public-private partnerships also very much required. It is not happening. The government can partner with private organizations such as industry associations and IP law firms to enhance IPR enforcement. Suppose you take any government organization, they are poor at litigation. Please note down. Suppose after completion of this FDP, you can give this topic to any LLM student for project work. Ask them to go and ask them to go and meet any scientific organization who are for IPRs, patents. Simply they will invent and throw ball on the administration. Whether that is working properly or not, whether government of India getting fruits on that invention or not, nobody is bothering. 99% are not bothering, because after that they have zero knowledge about litigation and enforcement. That is the reason I am really appreciating Jayan has chosen wonderful topic for me also. Really, if scientists, their organizations are there, even MD, even highest officer of any scientific organization may be from the science background. They don't know, zero knowledge about litigation and enforcement. That is the reason they must appoint one legal officer to take care of after inventions what is going. That is very important. That is also very important. That is the reason I am requesting all the faculty members to allot one topic and ask them to go and meet scientific organizations to get information. Next, crowdsourced information enforcement. The used crowdsourced monitoring and reporting system can help identify and prevent IPR infringement. Just now I said. Next, artificial intelligence and machine learning. The use of artificial intelligence and machine learning can improve the process of trademark and patent examination, making it more efficient and accurate. Just now I said, after introduction of information technology, many kind of things, sea changes are happening in the field of law, in the court system, e-court system, other kind of mechanisms. We are listening online courts every day. We are witnessing many things. Even Ari Salve also attending courts from UK. Very good developments are happening. But our people who are in the India, they are not utilizing information technology properly. I authored one book on online disputes resolution, law and practices in India. In that I mentioned many kind of things. Many kind of things. People are not utilizing online information technology for betterment of the other kind of things. Now I can say that for every reason, for every kind of problem, you can link up with the information technology for speedy disposal, for speedy kind of thing. Just now whatever I discussed, you can send through email to other party, and parties can attend through online and settle the matters by using arbitration through online. This is happening without wasting your time. You maybe, suppose in the case of international commercial arbitration, instead of doing physical, unnecessarily wasting advocate money and traveling time and flight money and traveling money, many pollution. Nowadays they are saying one of the reasons to advantages of arbitration, last advantages, you can say that pollution, to avoid pollution. Now many benefits are there through online arbitration. That is better. Our people are not encouraging information technology for this kind of problem. If you extend this kind of problem, many things are there. You know, blockchain technology is also kind of thing. For that also you can work for this kind of settlement, especially IPR settlements and everything. That is very good to the general public to respect and gain more benefits for their career as well as money, and society also feels very good. Thank you for one and all for giving me opportunity, and also now I can do some other kind of things. Please listen. Yeah. Now we have time.
Yes, sir. Yes, sir.
Okay. How much time left?
Sir, almost half an hour is left.
Okay. Wait.
But sir, we can take some interaction also. Actually, we'll have, if the participant wants to put some questions.
See, how many of you know pre-litigation mediation? Suppose pre-litigation mediation has become more popular nowadays. Without going to the court, directly you can go to Legal Services Authority. Please open your cameras, please. Please open your cameras. Jayant, please direct to all the participants to open cameras, because I can interact by calling their names also. While asking questions, I can give more information about that. But in the case of litigation, suggest them to go for pre-litigation. That means straight away people may go, people may go to Legal Service Authority, take legal opinion and file case before the Secretary Legal Service Authority. They are appointing mediators, arbitrators to settle the matters, and after filing that case before the Legal Service Authority also, you can get a order copy that order copy equals to decree. Suppose if you settle the matter before the legal services authority, tomorrow you cannot go to any court for appeal. That is the benefit you have. That is the reason in many cases, especially in the case of IPRs, suggest them to go to only pre-litigation kind of thing. You will get all kind of benefits from the legal services authority also. That is very, very important. Now coming to IPR and arbitration. And already I said, before going for arbitration, you must have arbitration agreement. Suppose if we don't have arbitration agreement, again we have to go to High Court for appointment of arbitrator. There we have got many problems. That is the reason to avoid all kind of practical problems which are happening after infringement of IPRs. Before only, while transferring or something, you must go for arbitration agreement. Just now I said, recently, contract administrators also become one profession in the field of law. That is the reason writing arbitration agreement skills are totally different, because clauses you have to write. 15 clauses, I can say. 15 clauses are there. In 15 clauses, you must follow very good language and legal points and many other issues which are related to IPRs. Then only you can avoid many technical problems. That is the reason now contract administration has become one of the important areas. Next one is, as per Commercial Courts Act 2015. As per Commercial Courts Act 2015, and mediation is also compulsory. This is very, very important. And pre-litigation is also compulsory, 2018 amendment. Again, just now I referred, all the institutions, organizations, universities, they must establish one grievance cell office at their own area, own compound otherwise. Because if you have that kind of grievance cell office, automatically you can solve many kind of problems there, your end only. Otherwise, after exhaustive kind of thing only, person has to come to High Court. That is the purpose of introduction of organizations. Please listen carefully once again. High courts are not entertaining your WPs directly. First of all, you must say that I exhausted. You have to promise that, your advocate, your counsel has to admit that my remedies are over. I exhausted my remedies. Then only this kind of things will happen. Okay? And yes, now I am ready to take your questions. Then I will explain whatever the doubts you have. Nataraj Gangadhar, please open your, I am requesting, not ordering, I am requesting, please open your cameras. Nataraj Gangadhar.
Nataraj, please ask your question to our respective speaker.
Mr. Nataraj, I have 25 years of teaching experience. I know what is going. And even today also I said, online ethics are very important. Suppose whether you are seriously listening my lecture or not, that is up to you. If you listen, you can become good teacher. If you are not listen, you will become bad teacher. That is up to you to decide.
Okay, now we are
Nataraj,
opening this session for a question and answer. Anyone who have any queries regarding this session, they
Lalit
can ask.
Kumar, Lalit Kumar, Mr. Lalit Kumar, you are discussing with others by after opening camera also. Please ask me any one question related to present lecture. Lalit Kumar, whether you are in the meeting or not,
All participants are kindly requested to switch on their camera.
Jayant, don't give certificates to these kind of people.
Okay.
Lalit Kumar, just now you opened camera, again he stopped. What is this? Neelam Chadda. No, not responding.
Whoever has raised their hand for asking the question to our respective
Sagarika.
please
Sagarika.
ask.
In my opening remarks, I said, all the participants must open your cameras. Simply they are attending and muting, that's all. Unmute, please. All the participants are requested to unmute, please. Tanuja, Devi Prabha.
Yes, sir.
Yes, sir.
Yes, what is your question? Have you followed my lecture?
Yes, sir.
You have any doubt?
No, sir.
Okay. Can you say any improvement is required? Can you suggest any improvement is required in the present system? Devi Prabha,
Yes, sir.
what is your
Sir,
question?
I'm sorry, I cannot turn on the camera. There are
Why?
network technical glitches, sir. I don't have like in my home, 3 of us using the network for the work reasons. So therefore, I have only one question which is in my mind, sir, with regard to copyright infringements when we discuss from the perspective of civil remedies and criminal remedies. Sir, this question I have it from a long time, right from the starting of GB Reddy sir's platform. The point is, sir, for example, if we as a student, when we write an article or a particular paper, research paper, like the history remains same always, right? So when we from the perspective of history, and for example, if it has to go in a particular sequence or order, can we say that it is a copyright issue?
Yeah. Devi Prabha madam, very good question you raised. Please don't talk. Don't talk. Please don't talk. Please listen.
Sir, I will mute myself because the dog is barking here. I'm sorry.
Devi Prabha madam, historical part may be same, but you must refer that history part from which place you have copied.
Yes, sir.
Otherwise,
Yes, sir. It will be given as a bibliography, footnotes, etc.,
yes,
etc.
yes.
Definitely.
For that reason, that is not comes under plagiarism. That is not comes under plagiarism. You can copy, you can take information for research purpose anywhere. That is not comes under infringement. If you use it for commercial purpose, gaining money, that is crime. If you use that part for research purpose, it is for academic purpose. That is nothing but you are encouraging the society by writing the paper, by referring books, referring material which you got from different textbooks and etc.
But sir,
That is not comes under infringement.
understood, sir. I'm sorry. I have one more question on the same aspect. So when we talk from the perspective of criminal remedies, why the criminal, I mean, in the present situation, we are not that strict when we discuss from IPR infringement rights. We don't, though we have enacted laws, legislations in our country, I don't feel that we are being strictly implementing or even if you implement, there are a lot of legal implications on those implementation is what my opinion. What is your opinion on this, sir?
You are asking about criminal remedies or civil
No,
remedies?
both, sir. We have a legislations in the present day, but the legal implications on the said legislations, there are criticisms, there are flaws in implementing these laws.
In my discussion, I given very good information about criminal cases, criminal remedies under copyrights and IPRs. Most of the police people, they don't know ABCD of IPRs. They don't know full form of IPRs. Even I inquired with them. They are clearly stating their training manual and other places always they will give training for how to arrest the people, how to catch the thieves, how to give punishment, how to use IPC for betterment only. They don't know IPRs. That is the reason in changing scenario, even police also must know basics of IPR. One lecture required their training manual. Number one. Number two is very important. They are thinking that IPR enforcement in the case of criminal remedies they are feeling that very less importance. Monthly, one, twice, they are getting that kind of cases. That is the reason they are not giving proper concentration on these kind of cases. In future, maybe 5 years, more cases I'm expecting, like metropolitan areas. Just now I said, if police people refuse to take complaint, immediately you must go to court. That is not happening in the case of IPR criminal remedies. You must suggest the people to go and file private complaint in the magistrate court under 200 CRPC. They are directing the police officer who are investigation officer, who are SHO of concerned police station. They are filing FIR, searching, seizing, arresting, sending them to jail. This is happening. But it is happening 6 months once, yearly, twice, thrice. Not regular basis. That is the reason your people are not witnessing more. In future it happens. Because of we have to make awareness among the general public, then only it happens, otherwise no. We don't have awareness kind of procedures. Suppose if you conduct any awareness camp, simply you will conduct family matters, constitution matters, consumer matters, like this, not IPR matters. I hope your people must come forward and do better things to make awareness, even this kind of things. Because tomorrow, today law student will become tomorrow advocate. Tomorrow advocate become IPR attorney. IPR attorney will get more kind of problems. If client comes, you can suggest them to go to police station by filing FIR. Suppose if police people say no, you can go to regular court, file private complaint. This kind of benefits are there. You must make aware in the among the general public. Okay. Next.
So there is a
Thank you,
question
sir.
in the chat box, like innovative lesson plan of the teachers, can it be registered under Copyright Act?
I'm not following. Repeat once.
Innovative lesson plan of the teachers, can it be registered in the Copyright Act?
Very good question. Lesson plan is the copyright of the professor only. First, that is very clear. Once it is, you are the owner, you can do any kind of thing as per the Copyright Act. You can register. Next, Vartika Singh.
Sir,
Yes.
Sir Devi Prabha, sir, I'm sorry. I have one question again from this innovative lesson plan. Sir, now, for example, in the private universities, we are supposed to prepare a course handout, which is
Yes.
similar to the lesson plan, the course
Yes.
work and the course handout. Now,
Exactly.
it's a subject of Muslim law or any law. We used to refer to the previous course handout. For example, in last semester, if a particular teacher is being handed with a particular subject, for the next semester, whoever the teacher is being referred to that particular subject has to see to the previous course handout. And there should not be more changes for the 5 years, next 5 years. Why? Because again, in UGC, according to this, not UGC, according to this NAC, we have certain norms like only 30% of the syllabi can be revised, not more than that.
Yes.
Now, if that is the case, how can we go and register for this copyright
Very
act?
good.
Means your previous year teacher is different from you. Yes or no?
Yes, definitely,
Yeah.
sir.
Yeah.
But
Yeah.
according to the university mandates, we are not supposed to change major of the structure, the plan.
Yes. Yes. I agree with you. Previous teacher, lesson plan, handouts are prepared by previous teacher. You can call she is the owner of previous handouts only. While preparing yourself, don't copy it. You can, whatever you are preparing, you must feel that it is innovative, new to your system. Suppose language may be differ and case law may be differ, many kinds may be differ, and you may become owner of your handouts. You can claim your ownership. So unless if she claims I already prepared, then you can give answer. You can say that is different, this is different. These kind of things are happening. Suppose you can last year Supreme Court case law in particular situation not there. Today case law came. Suppose in the case of family law, live-in relation is there. Yesterday Rajasthan High Court said even live-in relationship marriage also, live-in relationship also agreement is required. Many things are happening. By saying new things, you can defend your case. I am the owner of these layouts. That's all.
Thank you, sir.
Tanuja.
I would like to add one thing. I think that the previous participant, what she was mentioning, that 30%, more than 30%, we cannot make modification. I think this is in case of syllabus, not in lesson plan. Lesson plan can be individualistic to teachers. That's what I understand.
Yeah. Lesson plan is for department, not for individual. Syllabus is for department, not for individual. Handouts, lesson plans are individuals.
I'm sorry, sir. Again, Jayanta, sir, yeah, as you said, it is same. But for example, like in criminal law paper, like IPC or CRPC paper, in lesson plan, for example, we had to send the students to the police station in order to know how the FIRs is being filed. That could be one of my lesson plan. Or sending them to the coach in order to learn something, that could be my lesson plan. One of the activity which I'm planning to conduct my lessons accordingly. So there are certain universities, colleges where it is being considered as mandatory. Okay, this is the format you will have to follow for this particular subject. Since there is a requirement which is need in order to increase their grading structure.
Okay.
So
Yes, ma'am.
Yes,
ma'am, I agree. But my concern is whatever format has been given, that won't be innovation. How you follow the format? Suppose you said there should be one visit to the police station. That is the format. But what police station, what cases you are making them, how innovative you are making the students to write a report, that will be unique to you.
That is different. The format would be different from every teacher when we ask to submit their reports from the students. I agree that.
Yes, that is not only the format of the report, the process, how the report has been written, how the students have understood, which aspects they have taken into consideration. That guidance will be a lesson plan that will be innovative, man. And that can be different from one teacher to another. So
Okay.
copyright will not be there in the fixed format that has been provided by that means the procedures of the syllabus, that there will be no copyright because that is something which has been fixed. But how you carry out the procedure, that will be the unique to one individual to another, man.
Okay,
Whether the pedagogy of a particular teacher, like pedagogy is same, like we have different types of pedagogies. So now a particular pedagogy is being followed by 2 or 3 teachers. In such cases, would the lesson plan could be copyrighted?
Devi Prabha madam,
Yes, sir.
again I am clearing your doubts. Handouts, lesson plans are what you prepared, those are under your copyright only, not others.
Okay, okay, sir. Okay, sir.
Right. Next, the Damayanti. Damayanti,
Okay, sir.
please open your camera, madam, please.
If one university's syllabus is used at
Open your
another
camera, please.
university,
Open your camera, please.
eh, yes.
Okay. Any problem?
Yes.
Yeah. Now you can.
Sir, if one university's syllabus is used at another university, is it infringement of copyright?
This is very good question. Recently, I was in one of the meeting of National Law University.
Yes.
In that meeting, DRC members are raised one important question. Most of the national law universities are copying other law universities' syllabus and implementing in the new law universities. Okay,
Yes.
but no universities filed copyright case so far. I can say you can use that kind of syllabus for betterment of the education. That is not for making money. Here, very important thing is that if you copy something for research, for betterment of the society, not illegal. Okay, you can take that syllabus for your university for betterment of the education. You, after taking that syllabus, you can add something and implement it. You are not getting money, no.
Oh,
You are not going for commercial purpose, no.
yes.
You are not getting any benefit. Until then, it is correct.
Okay.
Right. Next.
Thank you.
Next, another part is 135 participants are there, but
I think
no one
sir,
is coming for.
Tanuja Sharma has raised her
Yeah,
hand.
Tanuja Sharma, please.
I think
Tanuja Sharma, open your camera, then I can explain.
connectivity problem.
Connectivity problem. Okay, you can share your idea with Jayanta. Kiran Nath. Prabhakar Rao.
Yeah,
So
yeah,
there
sir.
is one
Myself.
another.
Yeah,
Prabhakar Rao.
sir, you have spoken very nice about ADR. What about outbox settlements?
Outbox settlement.
Yeah, ADR
Wow.
is okay, nice. What about outbox settlements?
See, so far, outbox settlements are not recognized by law. Okay, but it is happening for taking legal advice to proceed further as per arbitration rules and legal services authority rules and etc. You cannot say it is 100% wrong. You can take that kind of help from the lawyers and legal luminaries and other people for betterment of the system only. But as per law, as per today's system is not encouraging that kind of outbox settlements.
Yeah, sir. Here, Kerala fisherman case versus Rome, Navy people.
Mm.
That was failed. High Court was failed. Kerala High Court was failed. Even then Supreme Court also.
Mm.
But the matter was settled in out-of-box settlement by Sushma Swaraj.
Mm. Okay.
Every fisherman got 10 lakhs.
See, this is out-of-box settlement means we are calling different names for that. Suppose what is going in the society, if original owner land is grabbed by one criminal, one other fellow, if he is not handovering, then immediately some other kind of people will go and settle the matter there itself. Okay, that kind of things are happening, but we are not. Maybe takes place, but in the academics we are not discussing such kind of practices. It is not a healthy kind of practices. Maybe settlement takes place, whether it is good, whether it is bad, up to them only. But so far we are not discussing in the academics. I hope in future you may open this kind of discussion also for academics.
Okay, sir. Thank you, sir. I am from MSS.
Yes, I know.
Okay, sir. Thank you, sir.
Yeah. Next,
Sir, there is one question.
Pawan Kumar. Ganga
No,
Mai.
sir.
Yeah, Pawan
Yes,
Kumar.
anyone who's having any queries, then they can ask to our speaker that we are approaching the ending of this session. So kindly please sum up with your questions.
Deepthi.
But I have one doubt. If because of we have to fight.
I'm not listening properly. Please.
If we have to fight at in generic gas, we have to fight it in intellectual property etc.
Please explain what she is saying. Mr. Jayanta.
Yes, sir.
What she is saying?
Ma'am, would you please type it in the chat box? Your voice is not coming properly.
Okay.
In the meantime, sir, I would request Aparna Subramaniam, she has raised her hand if she has any question. Actually,
Okay.
she wrote in the chat box also.
Yeah, Aparna madam. Aparna madam.
Sir,
Please introduce
afternoon, sir.
yourself. Where you are working?
I was working with Oxford College of Law,
Where it is?
Bangalore.
Okay, right. Please, what is your question?
My question is regarding artificial intelligence being used for writing assignments. Like majority of the foreign universities, they are having Turnitin or some other plagiarism checker in order to make sure that there is a proper balance between using of AI. But we don't exactly have that here. So I've seen personally students misusing it to a huge extent, wherein AI they could use to at least maybe in a proper manner where they can use it, but they are not using it in that way. So the quality is going down. This is something which I've personally seen. So what to do in such a situation? Like how do you guide the students, or as a teacher, what can I do?
Very good question. First of all, as a teacher, your idea is good, but here ethics are very, very important, madam. Suppose if you don't have ethics, we cannot do anything. Suppose in the same program, out of 120, many people are not opening their cameras. Even they are, I think they are in mute. Number one. Number two, coming to by using artificial intelligence assignments. Suppose if student wants to know more, and if he want to become something in the society, he must depend on his own knowledge to write the assignments. Taking information from outside is not a crime, 100% not a crime. But taking information from other side, other areas, it is addition to the your knowledge. Number two, while referring such kind of matters, you must admit by referring that book name, author name. Number three, suppose in it's not only in the law colleges, in the engineering colleges, I heard about very important note that they have to submit project reports in second year, third year, I think. 90% of the engineering students are depending on private organizations for submission of their reports. By giving procedure is like this, they will give topic allotment, what are the topic they allotted. After taking the topic, they are working on it. Finally, after checking the plagiarism, they are handovering that project report to the students. Simply they are coming and submitting. Here, even organization, colleges also asking soft copy, enquiring plagiarism, getting within the limitations, marks, award, viva, degree, everything happening. Who are fault with this kind of system? That is your major. You can think about this kind of practices are happening everywhere. Here, where can you find whether the student is wrong? He is going and taking help, and software is also showing his plagiarism percentage as per the norms, getting degree, going and becoming engineer. Society is going on. Same thing happening in the law colleges also. My answer is, they must feel that what is wrong, what is correct. Even parents also must inform to them values. Teacher can say 10 to 5 o'clock. After 5 o'clock, parents has to take care. Finally, I can say that ethical values only prevails in the system. That is my answer.
Okay, sir, thank you. Just one more addition I have. Would it make any sense to maybe bring in a subject as, like, for example, like ethics as a subject for when they are entering into the undergraduate course itself, maybe in the first semester? Is that because we teach professional ethics, but that is completely different from the normal ethics.
Yeah.
And it is very difficult to connect with the students, explain this to them when they are not actually learning it as such. This is my personal opinion. Thank you so much, sir.
Thank you.
Sir. I'm sorry, Devi Prabha again. I have one last question. I'll not disturb you again. Sir, with regard to Aparna ma'am's question in the plagiarism, I feel that okay, there are advantages and disadvantages too, because for the plagiarism, sir, continuous usage of 14 words according to usage, UGC, if it is copied, it will reflect as plagiarism according to UGC norms. Now, sir, for example, I have faced this difficulty personally myself. The usage of term Supreme Court of India and the case name, for example, Navtej Johar Singh versus Union of India. So now when we add this continuous line, it comes 14 words, sir. Now it has been plagiarized in my thesis. Now they asked me to change these terms. What can I change, sir? So what I have done, sir, like I have used the highest court, the apex court. I've used the alternative languages. So what is your opinion on this, sir?
Yeah. Taking court's judgments for your study is not copyright. Even if you quote same text also, it is not copyright.
It is not copyright, sir, but it shows as plagiarism. The percentage increases.
Yes, for that you in plagiarism checking, for that many problems are there for law scholars. That is, I agree. For that you ask plagiarism checking officials, you can remove this judgment attracting plagiarism. Then simply page number 4 or 5 or something, they will say while checking plagiarism, page number 4 is not comes under plagiarism, like that. Simply they are avoiding that kind of thing. But you have to defend yourself That is simply judgment, not copied. If I fail to quote that kind of judgment as it is not workable. How can I deviate? That is Supreme Court judgment. You have to defend your case, that's all. Then only you will survive. Otherwise, you cannot write. Okay. Next, Aparna madam, please. Over. Organizers, please.
Sir, just we'll be taking one last questions in the chat box. It is there about the Gamusa, GI of Gamusa of Assam that has been given GI tag, and handloom, they have been producing it for a longer time, but they are facing with problems. But still, for a long period, there is no litigation. That is one question. And this will be the last question for today, this session, sir, because we'll have to follow by another session.
This is comes under geographical indication, no?
Yes, sir. The question is a very long question. I have just summarized it.
Yeah. Very good, very good, very good. In Hyderabad, beside Hyderabad, we have Pochampalli sarees. Please note down. Ask him to, same handloom only. Please ask him to note down. Please, where is he? Please ask him to come forward. Please, where is he?
Sir, sir, please.
Okay. Jayanta, what is his name?
Good afternoon, sir. It's me, Trideep from Technical University.
Trideep. Very good, very good.
Yes.
Please, I want to see your face, that's all. Because very important question. Yeah.
Yes, sir. Actually, my
coming to-
research topic is on it, sir. That's why.
Very nice, very nice. Please take my number from Jayanta. I will give more. Because recently, say, one year back, one organization, one association came to me for registration of GIs. Okay, that is Pochampalli sarees. Beside Hyderabad, Pochampalli is there. In that area, in that place, many viewers society is there. Viewers society form one organization, and they went for registration. They registered now. Whatever the productions are there, all the people who are for that situation, that work, simply they are gathering one place. They are forming an office. Simply they will hand over such kind of production in the same place, and the association will decide rate. After deciding rate only, common, and for every, you cannot discriminate. Suppose if you are individual in the market, because of competition, you can reduce your rate. But in the case of geographical indication registration, you cannot reduce your goods, because that is going for society. Society which is registered under GI. Now GI is protecting your interest, and you are not involving in the selling of those goods. Simply you are producing and hand overing to the society, which is registered under GI. That is the reason here, who are producing such kind of goods, they are protecting and getting more benefits. And they are also protecting your rights. If any violations also takes place, GI organization is taking care of even your interest also.
Okay, thank you.
Right.
Understood.
Jayanta.
Yes, sir. With this, I request coordinator, please proceed with the formality.
Yes. Okay, so we are in closing of this session. We hope that all attendees are comes up with their questions and they resolve their queries, whatever they have in their mind regarding the session. So first of all, we are here to giving the vote of thanks. Myself, Pawan Sharma, Research Scholar, Department of Law. So we are thankful to our today's speaker, Professor N. Venkateshwarlu, Professor in Hand, Department of Law, Osmania University, for giving this insightful lecture. Thank you very much, sir, for making this session more interactive for participants and attendees. We are thankful for your insightful lecture regarding IPR enforcement in litigations. We hope that our participants will gain more information about it and they will enhance the knowledge in their career. So we are thankful to you, sir. Thank you very much.
Can I take you?
Yes, sir. Yes, sir.
Thank you for the opportunity.
Thank you, sir. It's our pleasure indeed, sir, to have like you, sir. We'll be very much expecting if we can get any opportunity to organize offline events. We'll be having you in physical mode also, sir. So it will be my privilege. But actually, offline are a bit expensive. So we'll definitely try to coordinate with sir.
Okay, Jayanta, please.
Thank you.
Best of luck.
Thank you, sir.
Thank you very much, sir.